Imagine two of the world's most famous apples. One apple belongs to the Beatles. That's Apple Corps, their music and media company. The other apple starts in a garage as a computer company. That's Apple Computer, now Apple Inc. Same name, very different businesses. In trademark law, that's a problem waiting to happen. Apple Corps owned trademarks for music and related entertainment. Apple Computer was building a brand for computers and software. Both wanted to protect their names. In the 1970s, Apple Corps sued, arguing that Apple Computer's name and logo were too close. They said it could confuse consumers and weaken their music brand. The companies settled. They signed what's called a coexistence agreement. In simple terms, this is a deal where two businesses agree to share similar names, but each one stays in its own lane. Apple Corps would handle music and records. Apple Computer would handle computers and technology. That worked for a while, but technology didn't stand still. Apple started adding sound to computers. Then it moved into digital music tools. Later came iTunes and the iTunes Store. Suddenly, the computer company looked a lot like a music company too. Apple Corps sued again, saying Apple Inc. had crossed the line. They argued that the new digital music services broke the earlier agreement. Apple Inc. said, basically, we're still a tech company. Delivering music digitally is just part of our technology. The case turned on how to read their agreement. What did music mean when they signed it? Did it only cover traditional records and tapes? Or did it also cover digital downloads and online stores? The court sided with Apple Inc. The judge said iTunes was a data transmission service, not a music label. So Apple Inc. had not breached the deal. Eventually, the companies reached a new settlement. Apple Inc. took ownership of all the Apple trademarks. Apple Corps received certain rights and payments. So, what are the lessons for law students? First, trademarks are not just names or logos. They are promises to consumers about who is behind a product. Second, coexistence agreements must be very clear. You need to think about future technology, not just today's market. Third, business models evolve. A company that starts in one lane can slowly drift into another. Old settlement terms might not fit new realities. And finally, this video is for education, not legal advice. If you have a real trademark issue, always speak with a qualified attorney. If you'd like to turn your own case studies into simple explainer videos like this, visit vidfactory.ai. You can create clean, animated videos quickly and easily without needing a full production team.